Okay, Shannon, put us on, please.
Yes.
Different Shannon. Sorry, my court clerk's name is Shannon.
Oh, I'm sorry.
No problem. Okay, we're here on the matter of Blake versus Morris. Mr. Kevin Miller represents the plaintiff, and Ms. Shannon Morris is present. So, Mr. Miller, go ahead with your motion.
Yeah, I have two motions. I have first a motion to enter a default judgment against Logan Morris. He's been served with the complaint. He never filed an answer. We had depositions even set up. He didn't appear for any of those. And so at this point, Logan Morris has never, and I would like to have a judgment entered against him because it's clear that he's partially responsible for this dog bite on my client. So we'd like a judgment entered since he has not responded.
All right. Obviously this is not for a sum certain. So I think I'm going to have to take some testimony to establish some basis for whatever award it is you're asking for. So I think we're going to have to set a time for you to present testimony from the plaintiff as to the extent of the injury. So I've got some basis for figuring out what the damage award should be, as well as it's helpful to me, counsel, if you're able to do some verdict research on other dog bite cases with comparable severity. So I've got some framework from which to operate. That's helpful to me. I don't have vast experience with personal injury cases. I've had a few dog bite cases, but I don't think any of them have actually gone to trial. They were all settled. So there's some framework for me to figure out what's an appropriate value. As I said, I don't think I can just simply enter a default judgment without taking some testimony. So we'll have to find a time for me to do that. So let's address your other motion.
All right. Yes, I wish to amend the complaint to actually include the lady that is on the phone at this point right now. She's not actually a party yet. I'm asking to amend the complaint to include her as a defendant.
All right, and I think the issue here is you got the name wrong. Instead of Sharon Morris, it was actually Shannon Morris.
May I?
That is correct.
May I interject?
Sure. Go ahead, ma'am.
She is not a party at this point.
Sharon Morris is.
Hold on.
Okay.
I understand, Mr. Miller, that she's not a party yet, but she's here. Let's hear what she has to say.
Okay.
Go ahead, Ms. Morris.
Thank you, Your Honor. My mom, Sharon Lynette Morris, is the homeowner. I rent from my mom. That's where the confusion comes in. Shannon Lynette and Sharon Lynette.
Well, whose dog is it?
Brandon Short is the dog owner.
And
the dog was, where is he? He's in Jackson. I believe he lives downtown. And the dog has been returned to Brandon Short.
All right, but the dog was at this 1569 Holly Drive address when the bite occurred?
No, sir. The bite happened at 5608 Holly Drive.
And who owns that home?
Sharon Lynette Morris, my mom.
And is that the home that you reside in?
Yes, sir.
I gotcha.
We do not have renter's insurance. So this would be like a personal lawsuit, which would
Yes.
bring bankruptcy to both defendants.
Well, and that's
So,
certainly what often happens
right,
when you're sued and you don't have insurance and you don't have enough money to pay to defend the case or pay of any potential judgment. Often that's what happens is bankruptcy gets filed, but that's simply a choice you need to make. What Mr. Miller wants to do is just to make sure he sued the right party. So, Mr. Miller, in a rental property that the homeowners are renting to someone else and have no control over the premises, there's no owner's liability for that, is there?
not to my
These are
knowledge.
all,
Hold on, I'm asking Mr. Miller.
Oh, I'm sorry.
Your Honor, I believe there's liability there due to the fact that they had the dog with them. This is the first time we had depositions on this. I've never heard of the name Brandon Short. The dog was Logan Morris's dog. It was in his room, came out of his room and bit my client.
The client,
The house,
Hold on. Let me hear. Ms. Morris, don't interrupt. I'll give you a chance.
no, I'm sorry.
Go ahead, Mr. Miller.
so yes, I believe there is liability here.
But it's not based on owning the home. It's based on lack of control or control over the dog.
Correct.
Okay. And your claim against Mr. Morris that you've obtained a default against or entered a default against is that the dog came from his room and bit the plaintiff. That's the allegation?
This allegation that Mrs. Morris is saying that another person on the dog is patently false dog was Logan Morris's dog. He represented that he owned the dog. He told my client that it was his dog, stored in his room at the house.
I don't even care who owns the dog. If the person who owns the dog wasn't present and didn't have control of the dog, the person who should have had control over the dog is the one that would be exposed to liability. So regardless of whether he borrowed the dog from somebody else, your allegation is he's the one that had control or should have had control over the dog at the time that it bit your client.
Correct. And the same with Shannon
Okay.
as well.
Shannon or Sharon?
Shannon. Sharon was that's her. We're wanting to amend the complaint to have Shannon replace Sharon.
I gotcha. Because you don't believe Sharon has any liability under these circumstances?
No, she does not.
Okay, so I think probably what you ought to be doing is dismissing Sharon from the case.
I've already done that, Your Honor.
Oh, okay. And I'm sorry. I'm looking at the top of the file.
Okay, Your Honor.
And yes, you can certainly amend your complaint to bring in Shannon Morris. Ms. Shannon Morris, that doesn't mean that you're automatically on the hook for this. It only means that he wants to prove a claim against you. So what'll happen is I will allow him to file an amended complaint. He will have to serve you with a copy of the summons and complaint. You need to make sure that within the 21 days of being served that you file an answer or you hire an attorney, either way. But if you do just nothing, he will be able to enter a default against you.
Correct.
Okay, Mr. Miller, I will grant your motion to amend the complaint. And then once Ms. Morris rather gets served and the case is at issue, I guess we'll see where we go from there. In the meantime, I mean, do you want me to set a hearing now, or would you prefer to only have to enter your proofs once on the default judgment?
I would, if you'd want it, I would like to go ahead and just, if you want to set a hearing now so we can take testimony on with regards to the injury. So that's fine, Your Honor.
Let's let me take a look at my calendar and see if I can give you a date right now.
Okay.
How much time would you need to prepare for that, Mr. Miller?
A couple of weeks, probably. I will say I'm going to be gone the first full week of July. So anytime after July 9th, I'm good.
All right, hold on a minute.
I have to add into that. I'm having surgery June 30th, and I will be out for 6 weeks.
Well, he's only seeking to enter proofs relating to the default judgment against Logan Morris.
Okay, I didn't know if it was something I would have to be.
Now, you don't have to be there. You could choose to be there once you're a party to the case, but this simply pertains to his desire to get a default judgment against Logan Morris. So let me take a look at my calendar here. So you said, all right, so I'll start looking beginning July 12th. We're probably talking an hour at the most, Mr. Miller.
At the most. And would you like these still by Zoom, Your Honor?
As long as the plaintiff is available by Zoom and I can inspect closely whatever remaining scars there are, Zoom is fine with me. You may attend in person if you choose, as may your client. But if you would prefer to attend by Zoom, you can do that.
I have no problem. I can come to Jackson. That's easy.
Okay. I'll leave that up to you. But the only caveat is if the plaintiff isn't here, I need to make sure they got good video so that I can see any remaining scars.
Not a problem.
Okay, I'm still perusing my schedule. Wednesday, July 21st at 9:30.
Your Honor, I hate to do this. I have a trial that day.
Oh, okay, that's fine. I had an opening there. I could do 2 o'clock on Friday, July 23rd.
I'll be there.
All right. Shannon, could you make that entry, please?
They're not going to get notices.
Yes.
So Mr. Miller, I think you are going to need to send notice to Mr. Logan Morris of that date and time.
I will do so.
We won't send out any notices, but I am going to get it on the calendar. So that's a
We'll do that.
hearing
I will send over appropriate
entry
orders.
of a default judgment. Okay, very good.
May I have a question? I have a question. May I
So
speak?
go right ahead, ma'am. Certainly.
Well, with these papers that I'm being served, will I have the chance to state my part of it? Because
Exactly. Yes.
some of the
yes.
allegations are false. And
So what you would do, ma'am,
yes,
the best course is, if you can afford an attorney, is
yes,
hire an attorney and make sure you get a hold of him as soon as you're served, and then he or she will know exactly what to do. If you decide you can't afford an attorney and you want to represent yourself, what you need to do is file an answer to that complaint, and your answer has to respond in numbered paragraphs that correspond to the complaint, whether you admit or deny, and if you deny, the reason why you're denying.
okay.
And then get that and file that with the court within 21 days after the day you're served.
Okay, understand.
Okay, very well. Mr. Miller, I'll watch for those. I'll watch for that order.
Your Honor, may I ask Ms. Morris a question?
Sure.
Ms. Morris, you stated your address is 5608 Holly Drive. I want to make sure you get the papers right. Is that still correct?
Correct.
Okay. And if you have any questions before you get an attorney, you can call me. So that's not a problem.
Okay.
So, Your Honor, I'll send over an order that says that I can amend the complaint, and also a default. I'm assuming we'll wait to enter a default judgment when you can name a, so to speak, a price. Speak.
I didn't quite understand what you said there, Mr. Miller.
I will send over the order that an order that allows me to amend the complaint. As far as entering the default judgment, I'm assuming you don't want to enter an order entering the default judgment until we have this hearing.
No, you don't need to send in an order on that. I've already blocked your time on my schedule. You just simply need to provide a notice of hearing to Mr. Logan Morris, and then file a proof of service of that with the court.
I will do so, Your Honor.
Very well. We'll see you back here on whatever date that was, which I've forgotten already.
Okay. July 23rd, 2:00.
Thank you. And like I said, Ms. Morris, you're welcome to attend that if you want. It's a public hearing, so you have every right to be here.
Okay, right, now did her counsel, is this not a trial? Is it just in front of?
Well, it's not a trial because Mr. Logan Morris is in default. In default means he failed to answer or otherwise defend the complaint that was served on him within 21 days of
21
service.
days.
Actually, he waited far, far longer than that before he entered the default. But he's not taken any action to defend the case. He's not made any attempt to try to set aside the default. The difficulty for me is because this is a personal injury complaint. In order for me to determine what is a reasonable amount of damages, I have to actually take some testimony. So I'll need to hear from Mr. Miller's client, not as to how it happened or why it happened or whose fault it is. As far as Mr. Logan Morris is concerned, his liability is fixed. He is liable for this by default. But what I don't know is the extent of the damages. So I need to hear
Okay.
testimony from the plaintiff, not as to how it happened, but how badly were you injured? How bad are the scars? You know, what types of injuries did you sustain? So that will be the sole purpose of this hearing. And then once I've heard
Okay.
that testimony, I will decide what is a reasonable amount of damages to compensate the plaintiff for those injuries.
Okay.
All right. Thank you. Have a good day,
Okay.
everyone.
Thank you. You as well.
You're welcome.
Thank you, Your Honor.
All right. All right. Bye
You're
bye.
welcome. So I don't know what these guys are doing here. They sent in a stipulation.
I just took us off the record. Do you want us back on?
I'll let you know. So I could have sworn I just signed a stipulation making this case go away.
Not quite yet.
Oh, okay. Hold on. I'll have Shannon put us on the record. I didn't mean the case go away. I meant the motion go away. But in any event, this is the matter of Blake versus, no, I'm sorry. That's the wrong one. That's the one I just did. This is the matter of, oh, I gave you the file because I thought we didn't need it anymore. Estate of Eli Jones versus the estate of Autumn Coffee. Counsel, state your appearances, please.
Yes, sir. Michael Dungan on behalf of plaintiffs. My bar number is 47051.
Alan Philbrick on behalf of the defendants, Your Honor.
Oh, I see it's actually set for a status conference. I don't know why I thought the stipulation I signed did away with this. Maybe I should have looked a little more closely. So we're waiting on a trial date here, or what is our status?
Your Honor, it's a wrongful death case. We have reached a settlement agreement for full policy limits. All of the interested parties have been notified of the case by certified mail this week, including the 60-day notices. 3 of the interested parties are unrepresented minors. I did email the court a proposed stip in order to appoint Jennifer Kelly as GAL for the unrepresented minors. We'd appreciate if the court could pull that up and sign it and get it back to me, and I'll get a copy to Jennifer. What we need at this point is a date a little over 60 days out. I think Mr. Philbrick was looking for a date around the first week of September, where we'll have a hearing on the motion to approve settlement and then also have a distribution hearing. We can do both of those on the same date. And as far as blocking out some court time, I don't anticipate that we need anything more than a couple of hours.
Judge, to
Do you anticipate a contest as to the distribution?
Potentially.
Judge, there are actually 2 estates in one lawsuit. There were 2 minors who were unfortunately lost their lives in this accident, and these so the 2 estates are both plaintiffs in the lawsuit.
Are they were the deceased siblings, or are they from 2 different families?
Siblings.
Siblings.
That's
Okay.
it's complicated. Yeah, it's blended, and they don't even have both. I don't think both of the decedent minors had the same 2 parents. They had 1 parent account, if I'm not mistaken.
I got you. So we've got some
Yeah,
blended family issues to address as well.
potentially, yes.
All right, I'll get with Nadine and have her find a date for you, and we'll set aside a couple of hours for it.
That would be great. That first week of September would be, I think, workable for both. If that's compatible with the court schedule.
Okay, we'll see what we can come up with. Nadine will get a hold of you.
Okay. Thank you very much. Nice seeing you, Your Honor.